Well, friends, at long last, we have an opinion from the D.C. Federal Circuit Court of Appeals about whether the people who were injured at the Capitol on January 6th can sue Donald Trump for their injuries. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, a really important ruling was just handed down by the D.C. Federal Circuit Court of Appeals. It is in the lawsuit that was brought by Capitol Police officers and members of Congress who were injured at the Capitol on January 6th as a result of the Trump-inspired, Trump-incited attack on the U.S. Capitol. And the issue that the appellate court had to resolve is, does Donald Trump have immunity? Does he have Presidential Act immunity? Does he have absolute immunity against being sued by the people who were injured as a result of the attack on the Capitol that he incited, that he inspired? And the unanimous three-judge panel ruled Donald Trump does not have immunity, and he can be sued by the Capitol Police officers, by the members of Congress who were injured on January 6th. Let's start by looking at the new reporting, and then I want to look at just some of the operative language, some of the important language in this new Court of Appeals opinion that was just handed down. But first, here is the headline from the Washington Post. Trump not immune from being sued for January 6th riot, judges rule. And that article begins, Donald Trump can be held civilly liable for the actions of the mob that attacked the U.S. Capitol on January 6, 2021. An appeals court ruled Friday in a long-awaited decision that could clear the way for lawsuits seeking financial damages from the former president. The unanimous decision by a federal appeals court in Washington is expected to be appealed, but could imperil Trump's argument that presidential immunity also protects him from being charged criminally for his efforts to stay in power after the 2020 election. 2 U.S. Capitol Police officers and about a dozen Democratic lawmakers sued Trump in 2021, saying he potentially instigated violence on January 6th by telling supporters the election was stolen and urging them to march to the Capitol and fight like hell. Now, friends, before we turn to some of the language in this newly issued Court of Appeals opinion, can I just ask one question? Do you really need to be a lawyer? Do you really need any legal training to conclude that a president who loses the election, who then gathers people together in Washington, D.C. on the very day his loss was going to be certified by Congress, Joe Biden's win was going to be certified by Congress, he gathers them together. He gives them a speech and whips them up into an angry frenzy with lies of their vote being stolen, their election being rigged, and their favorite president being unlawfully taken from them. And he then directs them to march to the Capitol, fight like hell, or you won't have a country anymore. Now get down there and stop the certification. Does it really take a lawyer or anybody with legal training to tell you that if a president does that, he should not enjoy immunity? He should not be immune from being held accountable for the consequences of his action, either civilly by being sued by the very people he injured that day, or criminally for committing crimes to try to unlawfully, unconstitutionally retain the power of the presidency. Anybody with a lick of sense could have told you that a president cannot be immune, must not be immune from being held responsible for his actions. And it took about a year to get this opinion from the appeals court. This case was argued by the parties on December 7th, 2022, and here we are, early December 2023. But better late than never. So let's turn to some of the operative language in this new court opinion. The court says, the sole issue before us is whether President Trump has demonstrated an entitlement to official act immunity for his actions leading up to and on January 6th. We answer no. When a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic. It doesn't care about who will occupy it next. And campaigning to gain that office is not an official act of the office. So friends, you see what the appellate court did there. They sidestepped entirely the question of Donald Trump's criminal responsibility for what he did on January 6th. They really didn't need to address it. This is a civil suit brought by the people that Trump injured at the Capitol that day. Donald Trump is also being prosecuted criminally for trying to unlawfully retain power, but that's separate from this civil suit. What they did here was they said Donald Trump was not acting as the president on January 6th. He was acting as a candidate trying to hold on to the power of the presidency. And when you're acting as a candidate, you are not acting within the scope of your official presidential duties. You're acting, if at all, within the scope of your duties or your desires as a candidate. The court goes on to flesh that out a little bit more in the next passage. Campaigning to gain the office of the presidency is not an official act of the office of the president. So, when a sitting president running for a second term attends a private fundraiser for his re-election effort, hires or fires campaign staff, cuts a political ad supporting his candidacy, or speaks at a campaign rally funded and organized by his re-election campaign committee, he is not carrying out the official duties of the presidency. He is acting as an office seeker, not office holder, no less than are the persons running against him when they take precisely the same actions in their competing campaigns to attain precisely the same office. So the three-judge appellate court panel held that Donald Trump is not entitled to presidential act immunity because he wasn't even engaged in presidential acts on January 6th. And this ruling by the appellate court has two really important consequences. First, and most directly, the Capitol police officers and members of Congress who were the victims of the Trump-inspired, Trump-incited attack on the Capitol on January 6th can have their lawsuit proceed through the system, and hopefully they will recover damages from Donald Trump. But the second important consequence has to do with Donald Trump's criminal case. Now you might ask, well, how does this ruling in a civil case have anything to do with Donald Trump's criminal prosecution pending against him in Washington, D.C.? He's indicted on 4 counts, various conspiracies to try to overturn the results of the 2020 presidential election. Here's how it applies. Donald Trump claimed he had absolute immunity against a civil suit being brought against him, Presidential Act immunity. And now let me tell you, friends, presidential immunity and government official immunity is a thing, right? What we don't want is to have our government officials, when they're acting within the scope of their official governmental duties, and they make decisions that might anger one or more of their constituents or of the American people, we don't want government officials tied up in lawsuits all day, every day, because some people don't like the decisions they make in their capacity as government officials. So there is a healthy dose of absolute immunity, including for a president, when that president is acting within the scope of their official duties. But there is no such thing as absolute immunity for crimes a president commits. So Donald Trump's lawyers in his criminal case said, well, just as there is this healthy dose of presidential immunity against being sued, against people bringing lawsuits for decisions he makes or acts he undertakes when he's president, there should also be absolute immunity against criminal prosecution for a president who says certain things or makes certain decisions or takes certain acts. He should be absolutely immune from prosecution for anything he does while president. Here is the beauty of this decision in the civil case. He doesn't even have absolute immunity for the things he did on and around January 6th civilly. So he certainly won't have it criminally. Now, there has never been a case, there's no law, there's no precedent, and there is no constitutional provision that says a president is absolutely immune from criminal prosecution for crimes he commits while in office, but there is this immunity from civil liability. So Donald Trump's attorneys are trying to import it into the criminal arena, and now they have not just a colossally steep climb trying to do it. I think this opinion in the context of a civil lawsuit saying no absolute immunity, no presidential act immunity, because he wasn't even engaged in presidential acts, basically kills any chance they may have had to import absolute immunity from the civil lawsuit context over to his criminal prosecution. So this really is an important ruling, a consequential ruling, both in the case for the plaintiffs, the people who are suing Donald Trump, the people who were injured on January 6th by the Trump incited attack on the Capitol, and in the future litigation in his criminal prosecution. So this ruling, although it took a very long time to be issued, is a really good thing on multiple legal fronts. So we can actually say that today was a victory for the rule of law. And that's a good thing, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.